The Center for Dispute Settlement is a private nonprofit organization considered a community dispute resolution center program.
Rather than going to court to resolve their issues, people can sit down with a mediator, a neutral third party, to hopefully work out what their differences are and set that down into an agreement or put it in paper.
Mediation is a process that allows people to have a constructive dialogue. A dialogue that helps them clarify their issues, put them on the table, and come up with ways to resolve their issues peacefully.
We're supported primarily by the unified court system, not exclusively, but probably about 60% of our funding comes from the unified court system through the state of New York.
Intake is generally done by the program manager or the case manager. This is a meeting before the mediation process begins.
I talk to them about the process, and the process is where the parties learn about how confidential our agency is.
The case manager would meet with either one or both parties to talk about what their concerns are, explain the mediation process, make sure that people understand. Most of the people who are referred to mediation have either started a court process or in some way talked to a judge or a clerk about having their dispute or concern resolved by a judge.
During a court setting, when the parties have come in after the filing of a petition, the statements that are made in court, the items of evidence that are introduced in court, all of this occurs during a public process. Family court is open to the public unless there's a specific application made to close the court. Mediation provides a much more private setting for the parties to discuss their differences and to work together to try to come to a resolution.
It's very intimidating for the parents to go before a judge, and that's true of any court. The judge has all the authority, and they know that he can make decisions that will affect their lives and their children's lives.
The court has laws and penal codes that set its boundaries. Mediation puts the responsibility for resolution back on the parties in dispute.
People very often are referred to mediation by a judge, but we want people to understand that the process is voluntary. We let people know that if they feel the need for legal advice, they may want to talk to an attorney, but by all means they would not need to hire an attorney to come to mediation. Mediation is generally offered to people at no charge. The court system has funded the program so that people don't have to pay, and so that they are encouraged to attend.
The court system is open to whoever wants to come into the room and listen to your business. It's just an open process. Mediation is a very confidential process. When people come to a mediation session, the door is closed and it's private.
Mediators are specially trained community individuals. They aren't necessarily attorneys or counselors. They come from virtually all walks of life. They attend a specialized training, 40 hours of training, and then they go through a structured apprenticeship, which takes somewhere between 6 months and a year to become a certified mediator. It's also important to note that in our family court program, most of the couples that come through our program have not been married. They have a child or children in common, but they have not been married, mostly because married couples or divorcing couples are handled in Supreme Court, and in family court they are not discussing the matter of divorce. They don't have jurisdiction over divorce. So in family court, most of the clients that we're getting have not been married. Many have not lived together.
About a year ago, Eric moved out. We were having some problems, and we made some arrangements, for Eric to see the children. And then it was going okay. Then I don't know what happened or what he was thinking. Then when he would have the kids overnight, he was only bringing back Sherry, and he wouldn't let Jimmy come.
Jimmy's 12, Sherry's 9. And there's a little bit of a difference at the time. And a boy has to sometimes you have to bestow manhood into him. She can't do that. I can't bestow womanhood into Sherry. So there becomes times where a man needs to be maybe a little bit more present at that time.
You know, you didn't
Jimmy?
you didn't tell me that you were keeping Jimmy until I was picking up the kids.
Well, why don't you check your messages?
You didn't. I did.
No, you
No,
didn't.
you didn't.
You're always
do all-
lying. Oh, yes.
Can I,
Yes.
okay, so you were concerned that he didn't notify you or let you know,
Right.
and as a result,
We
you're
haven't
upset
talked about
and
this at all. We haven't talked about separating the kids or anything like that at all. You know, the kids should be together. You know.
It's only overnight. You're talking. You're not. It's not like I'm
You
saying.
had
to,
Jimmy for a couple days.
It's not like I'm saying to you, okay, he's gonna come and live with me during the school year, and she'll go with you.
But look what
What?
you're doing to Sherry. Sherry thinks that you like Jimmy better.
No.
Well, that's what she thinks.
Oh, depends on who asks her the question, right?
Universally, these are failed relationships. They are no longer together as a couple, but they do have a child or children in common, and they have filed a petition in family court to have some of those issues resolved. Mediators are not judges. They don't make decisions for people. They don't impose solutions. They don't usually even make suggestions. What a mediator does is they listen to what parties have to say, what they wish to say to the mediator, what they might wish to say to the other party.
so your concern is that the
That he
kids are the
doesn't. He
brothers-
doesn't want me to have Jimmy.
Okay. Okay, Eric?
He's going through, different levels of puberty and stuff like that. These are some of the things she's not even telling her, or even starting to discuss with her. So maybe he feels awkward even talking to her about it.
That's not
you know.
it, Eric.
Can I finish?
When individuals come to mediation, again, it's their conversation, and that's what we think of it as their opportunity to talk about whatever it is they want to talk
How do I
about.
know if
In
he's
mediation, parents are empowered to make those decisions themselves. They are the ones who decide where their children will live, what the schedule will be. They're allowed in mediation to talk about anything that is of concern for them.
I just want what's best for the kids.
So what's best for the kids?
They should be together.
They can come to terms, they can develop the terms, they can be written and signed as a what we call a consent agreement.
Clearly, when individuals come to a mediation session and they leave with a written agreement in their hand, very, very often that they can take back to the court system, that's considered a major success.
If they have taken notes during their mediation, that their notes are destroyed so that people understand that this is truly a process where the mediator won't volunteer information to anyone, including the court, and they can't be forced by subpoena.
In my experience, the overwhelming majority of custody and visitation issues really do lend themselves well to mediation. It's a much more private, relaxed setting, and a setting where their own priorities, and by that I mean the priorities of the parents and their lives and their schedules, can be given a lot more consideration than in the formal setting of a courtroom where the judge must focus exclusively on what is in the best interest of that child. Sometimes that setting does not allow for the give and take kind of discussion and development of a solution that mediation allows for.
Ofrecemos servicios de mediación en español.